Greetings to all of you watching this video. Today, let us discuss about which is the best place for you to file a patent. One of the most frequently asked questions is where to file for a patent first, in India or US? In addition to India, the United States of America often is one of the favorite and lucrative destination for the applicants for filing a patent application. There are various reasons for this, such as US patent may hold better value in the market, time taken to get a patent in the US may be a little less, enforcement of law is better, and probably the market to sell a patent in due course of time is more mature compared to India. Let's explore the advantages of filing in India first and consequences of filing in the US first if the inventor is a resident of India. Before taking a decision on where to file first, it is essential to understand what does Indian patent law say about foreign filing. The issue is sensitive as well as critical, and lack of expert legal advice on the same may have fatal consequences. According to Section 39 of the Patents Act 1970, a person who is a resident of India shall not make applicant for grant of patent outside India without either taking foreign filing permission from the controller of patents. This permission is usually granted by the controller within 21 days and is required not only for foreign filing but also for filing a PCT application, or filing for a patent for the same invention in India, waiting for 6 weeks and then file in a foreign country. The term resident of India has not been defined in the Patents Act 1970, but according to the Income Tax Act, an individual can be termed as a resident of India if he stays for the prescribed period during a fiscal year, that is 1st April to 31st March, either for 182 days or more, or has been in India in aggregated for 365 days or more in the previous 4 years. Any person who does not satisfy these norms is termed as a non-resident. A resident individual is considered to be ordinarily resident in any fiscal year if he has been a resident in India for 9 out of the previous 10 years and in addition has been in India for a total of 730 days or more in the previous 7 years. Residents who do not satisfy these conditions are called individuals, not ordinarily residents. The main rationale behind having Section 39 is to safeguard national defense and security. If the invention is relevant for defense purpose or atomic energy, the controller shall not grant permission for foreign filing without the prior consent of the central government. Such application may be imposed under secrecy directions, and the controller may give direction for prohibiting or restricting the publication of such application if it appears to him that the invention in question falls in one of the classes notified to him by the central government as relevant for defense purpose, or the controller himself considers it to be so. However, this section shall not apply in relation to an invention for which an application for protection has first been filed in a country outside India by a person residing outside India. It is a myth that by filing in India first and US later, one loses on the date and the date of filing in US gets delayed. The fact is that even if you file for a patent in India first, you can file the same application in US immediately after expiry of 6 weeks from the date of Indian filing. At the time of filing in US, you can claim priority date from your Indian filing as both India and US are convention countries. Effectively, this means that even though you file in India first and US later, the same date of priority can be maintained in US as well as India. In fact, when priority is claimed from Indian filing, the applicant has to submit to USPTO the priority document obtained from the Indian Patent Office. If a person makes an application for the grant of a patent in contravention of Section 39, he shall be punishable with imprisonment for a term which may extend to 2 years or with fine or with both. Hence, it is important to either file application in India first or take FFP from the controller of patents. In the instances where the applicant is a resident of India, it is important to consider filing for a patent in India or taking permission for foreign filing from the controller before filing for a patent in foreign country or PCT, the reason being that violation of this provision can lead to fatal consequences. It actually does not matter where you file first, but yes, it certainly is a better and a safe choice to either file for a patent in India first or take permission from the controller for foreign filing. Thank you for watching this video. Check our website www.originipa.com for more such videos related to IPR. Do get in touch with us in case you need further information or assistance at our office, number 35, First Lane, Vaisya Bank Colony, BTM Second Stage, Bangalore 560076.